Criminal defense attorney right here in New York City and also an adjunct professor of trial advocacy at Pace University. Rob, so far, the defense attorney in this case seems to be a bit timid and getting answers I'm not sure he wants or expects to get.
He started off very well.
Right.
And it's called
in the prosecution's case by developing other possibilities for the injuries suffered by the victim in this case. And once again, I want to reintroduce my guest, Robert ALTCHILER, who's with us. He's a criminal defense attorney right here in New York City and also an adjunct professor of trial advocacy at Pace University. Rob, so far, the defense attorney in this case seems to be a bit timid and getting answers I'm not sure he wants or expects to get.
He started off very well.
Right.
And it's called the look good cross, where you're actually explaining to the jury your theory of the case and the witness is simply ratifying your statements. He wasn't even asking questions at first. He was just making statements.
Right.
And that's very good. Then he asked the question, he's trying to get to the point, he's trying to get help from the witness and have the witness say, yes, these injuries are consistent with two drunken people having sex. That's a big, big problem for him, and it's a danger sign, and he's not getting the answer that he wants. Now, he probably has an expert to testify, or he's consulted with experts that will dispute what this woman is saying.
Right.
But there are different ways to go about doing it, and I think that maybe he got hit a little bit in response to this question.
Yeah. Sometimes, I mean, one of the rules of cross-examination is you never want to ask a question that you don't know the answer to. So I guess, I mean, is that a rule? Is that something that you follow in the courtroom?
No, I don't follow that.
Not at all. Why?
No. Well, that's conventional wisdom, and that stymies many good cross-examinations. Sometimes there are questions that you don't know the answer to, but plausibility or how things have to happen tell you what the answer would be. Other times you continue to probe and even ask the question that most attorneys say you shouldn't ask, because if you're going against an experienced prosecutor, then as soon as you're done with your cross, the prosecutor will get up on redirect examination and ask that question anyway. So you have a better opportunity to put a spin on an unfavorable answer, and you're showing the jury that you're their legal advisor and that you are not afraid of the answers from the witness.
Yeah. They seem to be harping on this lubrication issue. This could go either way, whether she was in fact lubricating at the time of this particular incident or whether she was not, correct? It seems like both sides could play with that a little bit.
It's very hard. The nurse winds up being a very compelling witness for the prosecution because the jurors at the outset of the trial are focused on how could this injury possibly happen if this were consensual. Now, without bringing in experts to explain how the vagina works and the biology of the circumstances of this case, many people in the jury box are thinking this could not have been consensual. You will never convince me this was consensual. That is an uphill battle for the defense to fight. At the same time, the studies show that many times a rape victim will actually begin to lubricate during the course of rape, which kind of, cuts against what we would believe. So there is evidence on both sides here, and what we have, though, is we have the nurse being pretty compelling, and the image of severe injuries is something that defense will have a hard time overcoming.
Yeah, but wouldn't you think, as a defense attorney, one of the things he's going to have to do is he's going to have to create a number of scenarios to suggest why these injuries took place, right? And how can he possibly do that?
Well, I think that one thing he will do as he continues his cross is he will focus her on a number of different scenarios that could result in this. Now, the first time he took a shot at this, saying this is something that could happen if two drunks are going to have sex, she said no. If he takes her through different scenarios, for example, are there circumstances in which a woman who is consenting to sex could not lubricate? Could she be participating in this even as an awkward attempt is made to enter her? So are there circumstances that could result in these injuries from a person consensually trying to enter as opposed to unlawfully trying to penetrate? And there are ways, and he can kind of move the scale. What if she had 3 drinks? What if she really wanted to have sex but she was unable to lubricate? Can you explain to me a scenario that could result in these types of injuries? And the violence of the penetration in and of itself can be downplayed by the defense by using cross-examination in an artful way.
There you go. Well, we'll see how he continues to cross-examine her, because we'll have more when we return. Right now, we're going to take a quick break, and I want to remind you on the other side of this break, we're going to have, once again, another update, but this time we're going to have our own Clara Tuma, who is out in Cleveland, covering the Sam